Okay, so just let's start. Good morning, everyone. Thank you for being here with us this morning. Fran, oh, there's Fran. So we have the pleasure again, one more week, to have the New Mexico State Workers' Compensation Administration here. And of course, our partner, Fran Fernandez with the SBDC. So as Fran will just talk a little bit about how the SBDC can support your businesses. And of course, if you have any questions, please contact me. The webinar is being recorded, so you can check it out later. So yes, Fran, just take it away.
Okay, sounds good. Thank you. So like Sophia said, my name's Fran Fernandez. I'm the director of the Small Business Development Center at Central New Mexico Community College. And I just want to give you a little overview about how we serve small business owners. Our program, the Small Business Development Center program, was founded in 1989. We've been serving small business owners across the state for 34 years now. There's 18 small business development centers across New Mexico, and our staff, we have a skilled staff that is comprised of about 63 business professionals that have business management experience, that have business ownership expertise, and they're ready to serve you. Our program is funded in part by the Small Business Administration and the Mexico State Legislature. We operate through a cooperative agreement with Santa Fe Community College, and we provide service to small business owners across the state. Our mission is to develop skilled entrepreneurs and strong businesses. The Small Business Development Center at C&M provides counseling and training services to help our small business clients start their businesses, to grow their businesses, and most importantly, to stay in business. Some of our client services include our no-cost confidential business counseling service. We help people at all stages of business development. We also provide technical startup assistance to help our clients understand the steps to start a legal business in the state. We do work with existing businesses as well to help them continue to thrive and to grow. We also provide business and marketing plan assistance from just getting started and working through the plan to also reviewing completed plans. We can review available funding options. We help assess the best options for our clients. We also offer bilingual counseling and support services to our Spanish-speaking business owners in our community as well. And, to help our clients become skilled entrepreneurs, we do offer low to no cost business education workshops and trainings through our online training portal. There's just so many advantages to working with the Small Business Development Center at C&M, as well as our community partner, the Minority Business Development Agency, as we all want to help you and your small business succeed. I encourage you to please visit us online at our website there, www.nmsbdc.org, to learn more about the program. You can also register for counseling and training services online, and you can also
It is me or Frank Prost?
Yeah, I don't hear Fran anymore.
Yeah, it's just kind of froze there.
Fran, I think we lost you. Are you still there? Okay, so if you have any question from Fran, please reach out to her, to SBDC. There's a great resource. So please, Jessica or Jose, please take it away.
Thank you, Sophia. Oh, I think Fran's back. Here we go. Lost her for a second there. Here she is again. Let me give you a chance to finish there, Fran.
Oh geez, I don't even know how when I my internet keeps going.
Oh,
what's going on?
Virtual meetings. So let me mute here. So
Thank you for your kindness. So basically, the SBDC is here to serve you. We do a lot of different services. We provide counseling and training services. So please come visit us at our website, www.nmsbdc.org. Thank you so much, Jessica and Joey. Thank you for your kindness, and go ahead and continue, please. Thank you.
thank you. Okay, so I'm going to jump right in, and so everybody can see my screen, right? So we're doing a part 2 from the workers' comp presentation that we did last week. So who knew that there was so much to know about workers' comp, right? But it's actually a lot to learn about it. So we're going to touch on this week on the return to work initiative and getting your workers back to work after the workplace injury. Last week, what we really tried to focus on was when you need workers' comp, and give some basic ground rules about how workers' comp works and what our agency does, as well as let you know the different services we have to offer. One of them being helping you with a return to work program. So we're going to tag team again. I have Joey again. You know what? Let me go ahead and introduce myself again. My name is Jessica Sanchez. I'm the Medical Cost Containment Bureau Chief here at the Workers' Comp Administration. And I have Joey Frescas.
Joey Frescas, I'm return to work specialist, New Mexico Workers' Comp Administration.
Okay. All right, we'll go with our part 2. So here's some of the names that we've been called in the past. Some of the nicer names probably it's the big bad wolf of workers' comp, OSHA on steroids, and that is because we are the neutral regulator on workers' comp. As we mentioned last week, we have a mini district court at our offices. So if there were to be a worst case workers' comp scenario that you were involved in, those would be mediated and heard at our office. We have mediations, mediators who are lawyers, and also 6 judges who hear those cases. So what we're really telling you is that if we can educate you here at the front end, you can avoid some of these worst case scenarios at the back end here at our offices. So that's really what we're trying to do today. We are the neutral party. We don't sell insurance, as we stated last time. So what we're giving is general information. If you want something specific, you can talk to your own risk manager if you have one, or claim administrator for items specific to you. But really the idea is if you are proactive and plan for that workers' comp injury ahead of time, so you know what you're supposed to do, you can avoid that workers' comp worst case scenario, AKA a much more costly claim, right? So you're saving time and money by doing some of the steps that we're going to present you here with today. And when we're talking about return to work, the definition we have here is basically getting somebody back to work as soon as possible in a responsible way. So not violating light duty work restrictions, not bringing them back before the doctor says they're able to come back. We're talking about a responsible and safe return to work after the workplace injury. And when we're saying have a return to work program is what we really encourage, is really, we think of it as helping the worker, excuse me, I'm still fighting this cough here, in a limited capacity. So from the date of injury, we're talking about bridging them through until they can get to a full duty work release, or what's called maximum medical improvement, where a doctor says that they're as good as they're going to get. So we're telling employers that they can help workers through that healing period, right, when they're recovering from their workers' comp injury. And even though our focus today is on workers' comp, we do encourage a return to work program for all injury and illnesses, even ones that happen off the job, especially if you are subject to ADA requirements or the American Disability Act. So small businesses oftentimes are not subject to the ADA, but it's a good idea. It still helps you save time and money if you're able to help those workers through that. So if we were doing this live, we would ask people here, the audience members, unfortunately, we're not able to see who we have here in the audience because of the webinar set up here, but we would ask if you have a return to work program. And sometimes employers will return their workers back to work, but they don't have an actual program in place. So what we're really trying to promote is you having an actual program started off, because you're much more likely to follow through and get the best result from that. So we're going to go over the importance of retaining your worker post-injury, how to accommodate light duty, best practices. We have a toolkit preview and some workers' comp rules and regulations. And if you have questions, please type them into the chat or the Q&A section, and we'll try to get to those as we go through. So even though we can't see you and kind of have a conversation, maybe we can get those questions going and we can answer them as we go along. So one of the things we often get asked is because return to work took on a new meaning when we talked about COVID. And so that threw a new wrench into returning somebody back to work. So these are the kinds of questions we were getting when COVID started. Is COVID a compensable workers' comp injury if it happened on the job? It very well could be. We have had hundreds of COVID compensable workers' comp claims. So the answer is it can be. If a worker reports COVID as a workers' comp injury, you just go ahead and take that report, pass it on to your claims adjuster, investigate the claim, let them make the determination on if it happened on the job or not. So you don't have to make that determination, but always take the workers' comp report. We'll talk about that more later. If it is a compensable workers' comp claim or injury, then medical and indemnity payments could be due, or medical at least, possibly indemnity if there's some lost time. If you think that COVID happened off the job, still take that report of injury. And if you sometimes, like I said, we were getting questions about a COVID vaccine, if it caused side effects and you were requiring it, is it a compensable workers' comp claim? Again, it could be. So what we've just advised people is to contact your workers' comp insurance company or legal counsel for guidance on how to deal with COVID-19 reports of injury, but they can indeed be compensable claims. So we're not going to dwell much more on COVID because it's its own animal, right? So here we're going to launch into workers' comp trivia. If we were doing this in person, fortunately, you guys are missing out. We would give little chocolates out or somebody who got the right answer. So I'm going to ask Joey the questions. See if Joey knows the workers' comp trivia. And these are basic questions that we have, that we feel that really every employer and every worker who is subject to workers' comp should have a general idea about. So first question is, every employer must have blank in a conspicuous place. And if you were here on our part 1, you should kind of have an idea of what we're talking about.
Okay, well, the answer to that is you must have a workers' comp poster
Yay,
in
he
a
passed.
conspicuous place. So you
I
have
a
the
chocolate to
poster.
give you, but
And with that is a notice of accident form, which goes attached to the bottom of that poster. So try to have it. I think most people put them in break rooms, kind of a common area if you can.
yeah. And here's the other caveat: read the poster. And I even had, I mean, I'll admit this, it was an internal employee asked me, do we have a bilingual copy of the, or do we have a Spanish copy of the poster? And I'm like, oh my gosh, it's a bilingual poster, right? If you have ever actually read the poster, you would know. Yes, so it tells you about basic requirements under workers' comp. So I would say read that poster as well. And if you need some of those, you can contact our office, we'll get those to you. You can also download them off our website. All right, so number 2, amount of time a worker has to report the workplace injury.
A worker must report the injury to the employer within 15 days, sooner better. And they can do that by using this notice of accident form, which would be attached to your poster.
Yes.
You just fill it out. If you got them from us, they're carbon copies. If you printed them off the internet, obviously they're not going to be, but employer keeps one copy, the employee keeps the other if you have these kind. And if you need them, we have them.
Yeah. And those are the notice of accident or the NOAAs. But here there's a couple of things to add on to that. So even though our statute says 15 days, if you don't have the poster up, that goes to 60 days. However, the employer should never make that determination on their own. So you're thinking this happened 15 days, this happened 16 days ago, I'm going to just not report this claim. That's a huge no-no. Don't ever not report a workers' comp claim to your insurer. Even if you think you're outside the 15 days, outside the 60 days, that's not for you to make that determination. take the report, then express your concerns to the insurer, your adjuster. They can investigate that. They will decide on if it's outside the time frame and if it's a compensable workers' comp claim injury. So, and here's another thing that we encourage, even though our statute says 15 days and then there's a 60 days without the poster, you can have an internal policy, a return to work policy, where you want them to report in 24 hours. And that is really beneficial. We encourage that because you want to know about that injury ASAP. So that way you can investigate it correctly. You can stop the worker. Let's say they slipped and fell. You don't want them to get injured even further. You don't want other injuries to be caused because that might be a hazard. So there are several reasons why you want to know about the injury right away. So you can make that your internal policy. However, even if you think that the worker is violating that policy, they're outside the 15, 60 days or whatever time frame you're thinking, still take the report. Joy, do you have something to add on to that?
Yeah, I was just gonna recommend that you also need to fill out the middle section as the employer. And you see it says employers insurer claims representative. That needs to be filled out because it should be common knowledge within your organization.
Yeah. And a little tip for you as well. It's about the size of an address label. So you can print those out. And if you need to replace it at some point, you can. So and that way it looks a little nicer that way.
I think we had a
So-
question there.
Yeah, the amount of time the employer has to report the injury and illness to the insurer.
The amount of time is 72 hours. Again, the sooner the better. I try to get it done as quickly as possible, but you do have 72 hours.
Yeah. And that's when you have knowledge of that injury. So even though, yes, you want the notice of accident, you can ask them to fill that out. But even if you don't have that filled out, don't keep that from stopping you of reporting it. So you do need to report that even if you don't have the notice of accident filled out. Okay, you probably would want that filled out right away. So if you hear that the workers' comp claim happened, the workers' comp injury from whoever, a coworker, then you can go to that person and say, can you fill out the first report of accident for me? If they, but like I say, if you don't have that piece of paper, still report it to the insurer. Okay, employers should never do this.
Employers should never do this. Retaliate against employees. Definitely don't do that. Treat them any differently because they filed or gave you a notice of accident form. I think you also remembers when you get the notice of accident form and you sign it, that doesn't admit guilt on the employers. That does it just means you're accepting the notice. So keep that as part of it. But and always report. You should never not report, if that makes any sense.
Yeah. There's a couple other things that we talked about before. Don't ever, for the sake of not reporting to the insurance company, try to pay medicals out of pocket or say, hey, let's keep this on the down low. I'm going to try and pay this. I'll pay for your medical bills. You don't have to report. That can really blow up in your face badly, especially if it comes down to our office getting involved. We do have a WCA enforcement bureau that investigates that kind of thing. So try to circumvent workers' comp statute or reporting. Don't ever do anything like that. Also, if you are subject to the workers' comp, if you have the 3 or more employees that we talked about, or if you have the CID license where you are required to have workers' comp insurance, don't ever not get it if you know that you're supposed to have it. Because again, we have that fund where we have people who go after employers who do that for fines and penalties. So there's quite a few things like that fall under that. And besides purchasing the workers' comp policy, employers pay what?
Well, employers pay a quarterly fee. It's $4.50.
30
And
cents.
is it 30 cents? Okay,
Yes,
$4.30. And but they can pass $2 of that on to the employee. So you may see that on your pay stub every quarter. And what that does is it funds our agency. It's not, doesn't mean you have workers' comp insurance or you're paying into a workers' comp insurance plan. It's basically a fee. That's how we operate and offer the free programs that we have and do the enforcement and so on.
Yeah. Okay, and so how and when should the employer communicate initial healthcare provider selection?
Well, you should definitely put it on the poster. You can, that's one of the reasons to have it on here. I think, no, that's not correct, is it?
No, it's on the
No.
notice of accident.
Yeah, it's on the notice of
Yeah.
accident form. I'm sorry, but you need to communicate that to your employees often. You can do it during safety meetings, but it needs to really happen before an injury, so that they know whether they can choose their own physician. And keep in mind, not all physicians take workers' comp insurance, so if that's your decision is to let them have the first choice, then they need to understand that they have to go to a physician that accepts workers' comp, because not all of them do. And you can also choose to send them to the physician. You can have first choice, but as we talked about last time, keep in mind, if you choose the physician or healthcare provider the first time, after 60 days, if the case lasts that long, they can choose the second one, and then that's the one that's kept the rest of the time, or vice versa. If they choose the first time after 60 days, the employer can choose the second healthcare provider.
Yeah, exactly. And if you have questions on if you should choose or not choose, you can speak to your workers' comp adjuster and ask them if they have a recommendation, if that insurer suggests something, or if they let you do it. So it really is a business decision, because the employer has the option to make the first choice or allow the worker, but you do want to communicate before they seek health treatment. Going to the emergency room is not considered a choice. So if they have to go to the emergency, don't, try to stop them or whatever, so you can choose a healthcare provider. If they go to the emergency room, that's not really a choice. You want to get prompt healthcare. If they need to go to the emergency room, just let them go. All right, and then next, number of cumulative missed days before last time indemnity is due. Or that's the last time payouts.
Yeah, so it has to be 7 days of cumulative missed days before they are eligible to receive any lost time indemnity from the insurance.
Yeah. So you, as the employer, you want to be tracking how much lost time is being taken. Sometimes if they're able to use sick leave, it can get confusing, but you still want to be tracking how much time they have lost due to the workers' comp injury. Also, if you have to pay out lost time indemnity, the adjuster is going to be asking you for payroll records. So that's why you might get asked that, because they figure out a calculation for average weekly wage, and that is what they will get for their lost time indemnity. So just know that that's another of your responsibilities as an employer, is to hand over payroll records if lost time indemnity is due. And number 8, claims administrator, which is the adjuster, basically submits to blank to the WC after 7 missed days.
So whoever the claim administrator is for your organization, whoever's handling it, you need to submit what's called the first report of injury to the workers' comp, to us. Jessica, is that, and this is a question for you, is this still called an E1?
Yeah, the E1, or they call it the FROI, E1, first report of injury, or the FROI. So that is, there's the no one, there's the FROI. The no is the notice of accident, FROI's first report of injury, and it's strictly a data reporting form.
Yeah.
And it has the same kind of information you would probably need to provide if it's an OSHA recordable. So you can use that information on this form, but it is a totally separate form that the WCA requires for our statistical purposes, and the adjuster has to submit it to our offices. So they're probably going to ask you for that type of information.
Yeah.
So you might either do that electronically, or they might have you fill out the actual E1 form itself. So that's a whole separate form.
Yeah,
for
so
us.
just keep in mind, notice of accident was with your poster, and then the E1 is a separate form.
Yes, exactly. Okay, so good job, Joey. You know, all right.
Jessica, there is a
Uh-huh.
question on the question and answer section.
Oh, I'm sorry. Was there a question? I'm not seeing it on the chat. Hold on a second. Let me see.
Hold on, I'll ask it to you.
Are you seeing it?
Okay,
Okay.
yeah. It says, are there any other reasons an employee could have 60 days to report rather than just the 15?
It's mainly if they don't have the poster up. But we've seen, remember we're talking about the worst case scenarios, we've seen cases go all the way to hearing. And I've heard from a workers' comp judge that it's hard to win on non-reporting. So that's why we say always err on the side of reporting. It really doesn't, it's not to your advantage to kind of put out this idea that, oh, I don't want to know about injuries because then people are scared to report. So then you have a situation where you have a slip and fall, no one tells you anything, you find out two months down the line, it's become a worst case scenario kind of thing where the injury's gotten worse because that person, rather than stopping and trying to take care of the injury, they keep working full duty, and then it becomes worse. Then we're talking about more expensive medicals, some lost time. Then they feel like maybe the worker or the employer is not helping them through the process. They get legal representation and they say, well, because of the work environment, I didn't feel comfortable reporting the accident. You know, something like that could come to our offices. So we always say, just err, say, you know, when in your return to work policy, safety policy, report the accident as soon as it happens. And in that way, you just cover yourself. And even though it kind of seems counterintuitive, you really want to foster that workplace environment where you want to know about the injuries ASAP, so you can report those.
Yeah, one thing I always recommend employers do is it's really part of your culture. So maybe have a staff meeting, maybe at your next staff meeting, you know, go over the poster, go over the notice of accident form, and just kind of put it out there, you know, that you do expect them to report, and it's okay to report. Just create that environment of communication. I think it saves a lot of problems.
Exactly. Okay, so why should your business care about return to work, especially if you're a small business and you're not subject to ADA requirements? Well, here's a picture, especially in this job seeker kind of environment where it's hard to recruit somebody, especially if we're talking about a specialized job that takes a lot of training. You really want to retain those experienced staff, and onboarding, all that takes so much time. So creating that culture of, you know, return to work really helps you retain those staff. So that's where it really helps the small business owner, is by retaining those workers and getting production out of them as opposed to just paying them to sit at home. Because essentially when you're paying your workers' comp claim, it's, you know, that's one of the things we're trying to get across in these trainings, is that it really is your money that the insurance company is spending on these workers' comp claims. So rehiring, so just to be clear, under the New Mexico Workers' Compensation Act, this is what it says as far as requiring somebody to come back. So after the person is at what we call maximum medical improvement, where I said that's as good as they're going to get, where the doctor says any more treatment is not going to make a difference. This is the max, you know, the max improvement that can happen after this injury, or at the full duty point. If you, the employer, are hiring, the worker applies for their pre-injury or modified job, the provider says that they can do that job, and you have that pre-injury job or another one available. So those 4 criteria, if you have those, then you have to rehire. So when looking at this, of course, there's a whole lot of wiggle room. ADA trumps the workers' comp statute that was put into place before the ADA really changed to talk about reasonable accommodations. So if you're subject to ADA requirements, you can almost ignore the workers' comp requirements because they're a lot less strict. Same with FMLA, if we're subject to those as well. Under the Family Medical Leave Act, if you have to provide leave. And so even though it's not required under our workers' comp statute that you accommodate somebody, especially during that recovery period, there are a lot of reasons why we really encourage you as an agency to do that. And that's what this whole presentation is about. So that's what Joey, I'm going to tag team here back to Joey, and we're going to take turns here on different slides. So
Okay.
take this one, Joey.
All right. So if you look at this slide, it says probability of return to work if injured worker not returned in prior quarter. So in other words, if we look at the graph, you see the 1, 2, 3, 4 across the x-axis there across the horizontal part. Each one of those is a 3-month period. Okay. So can you go to the next slide? All right, so that's going to be 6 months where the circle is. If an injured employee is out of the workforce because they're injured, because the doctor said they're injured, and they're not able to go back, maybe because you don't have a return to work program, you can see that almost half of them at that point aren't coming back. And the longer they sit out, the less likely they are to come back. If you go another 3 months, now you're only to 32% of employees will come back. And you go all the way out to 2 years, 95% of people are going to not come back to work. And I think if we kind of just look back at COVID, that's just a perfect example, because the longer people were out, the less likely they were to come back. So it's the same thing with injuries. It could be for various reasons. Maybe the injury's gotten worse, or it could be depression, lack of motivation. There's just a whole gamut of reasons, but the gist is the longer they sit out, the less likely they are to come back. And you can kind of see that by the graph. I know at the bottom, if you look, it says Washington State Department of Labor and Industries. This is where the data that this particular graph came from, 2011, 2012, but it's pretty much the same. I mean, it hasn't changed a whole lot. Where we kind of see some improvement on some of those numbers is when people have return to work programs, so they can kind of integrate those people back into the labor force a little quicker. We can, okay, a return to work program. Again, we can help you set that up. We suggest a written program. Again, we can help you set it up from beginning to end, but there are some advantages. If you look at the box on the left, it says employee wins. It's been shown that employees that are hurt and they work at a place of business that has a return to work program, they do have a faster recovery. They maintain their routine somewhat, kind of depends on what their restrictions are. They still maintain their social network. They're not isolated, they're not at home. They're less likely to go on permanent disability. They're less likely to have secondary injuries, that are secondary to the original injury. It does ease the financial burden on them because they're at work, even if they're at work part-time, and maybe the next part of that second part of the year is covered by indemnity payments from workers' comp. They still have an income, so the financial burden's less. And depending on the structure of your business, they do retain their seniority. Maybe they retain their health benefits, health insurance, or retirement benefits, whatever it is, depending on how you handle that. If you look at the employer side, the indemnity payments are reduced. That means the insurance is not paying wages, maybe as a high rate, because maybe they are back part-time because that's all they can do. And they're only paying the other half, or they maybe not be paying any. It just depends on how you brought them back. So the medical payouts are going to be less, which means lower premiums for you. Hiring and training, we all know how hard that is and how much time that takes. That saves you money there. You're getting some production out of the employee. You will appreciate that because they're still producing something. and they're going to appreciate it because they're back in there. It does reduce fraud, and it is a morale builder because what you notice with businesses that have a return to work program is the morale among the employees tends to be a little bit higher because they understand if they get hurt that the employer is going to try their hardest to get them back into the business, into their job, or maybe a modified version of their job, and they're just not going to push them to the side. And it does make a big difference on morale. I think that's it on that one. You're muted.
All right, oops, unmute. All right, thanks, Joey. I was already getting ready to go to the next slide. No,
Okay.
So one thing we get asked from employers, of course, is show me the money. And what we say is that the insurance company really sees you making that decision to not return somebody back to work as them having to pay out more money on your behalf, because that means, as Joey had said, more medicals. If they decide to get a lawyer, well, guess what? The insurance company has to get a lawyer to fight that lawyer, right? So that's more legal costs. And usually the worker tries to get a lawyer when they feel like the employer is not helping them through the process, that they're not being heard by the adjuster. So that's usually when you got the legal fees. And when the lawyers get involved, any opportunity you had to contain costs on a claim is basically out the window. Then there's the indemnity, the lost time, that's the big one. If they're out, the wage replacement fees. And if they don't return back to work to their pre-injury job, to the pre-injury wage or more after they're at that maximum medical improvement point, there's these cost points that are tacked onto a claim that can inflate it exponentially. So a $10,000 claim can easily balloon to a $40,000 claim. And do you really think that the insurance company is not going to find a way to pass that on to you, the employer, right? They're not going to just pay extra money out of the kindness of their heart. They're going to try and recoup that money in some way. So you will likely see that in higher deductibles, higher, different ways that they have of charging you more on your premium. So always we're trying to get across the idea that the premium really is your money. So you can control how much that premium is going to cost by having some of these risk management things in place. So having a return to work program, having a good safety program in place. All right, so we're going to go through these. I'm seeing we're kind of going on time. So I don't know if you want to run through the first 6, Joey, and then I'll go through the next 6 pretty quickly.
Okay, early return to work. So all the things we just talked about, it does affect your bottom line, but it also helps your employees. They feel higher morale and so on. So we have what's called a dynamic dozen, and there's 12 main practices that and we can help you set those up, but they kind of guide you through the program. Go ahead and okay.
And
so
I'm sorry, just tools for all of those are available on our website as well.
Yeah. Okay. If you're interested in starting a return to work program, we do a one-on-one consult with you. We could do it over the phone. We do try to keep it pretty short because we know you're busy. But what we do is kind of find out what your business is like, what you may already have in place. If you have stuff in place, we may grade you on it. You're not going to get in trouble if you get a D or if you fail something, but we do grade it because what we do is we're going to figure out where you are when we start and where you are when we finish. And hopefully you'll see an improvement in your practices and your return to work program. So the ultimate goal is for you to become a return to work champion if you decide to do this program, which is voluntary, by the way. It's not mandatory, but that's our goal, is to have businesses recognized as return to work champions. And we do have several that have done it, and we guide you through the whole process so it's not so overwhelming and time consuming. Okay. Return to work best practices. So think back to your most recent injuries, if you've had any, and how did your organization handle them? We're going to go through some practices that or steps that you can have in place before you even have an injury. So someone in your business, and again, it depends. If you're a really small business, you know, the office manager is also the safety director, is also the workers comp rep, is, I mean, you wear a lot of hats. But you do need to have someone who's the designee. Who do they go to if there's an injury, or who do the supervisor go to if there's an injury? So try to have someone in that position, and they can kind of oversee all of this stuff that needs to happen with a workers' comp injury. And that's kind of the best place to start. Okay, number 2, have a written policy. We can help you write the policy. In fact, we have a lot of resources on our website, and actually all 12 of these are on the website, like Jessica mentioned. And if you go on there, there is a like an outline basically, and it's in Word form so that you can go in and change and adapt it to what you need, but we can help you do that. And you have a written policy. There's checklists for who needs to be communicated to, who the NOA or the notice of accident form goes to, and so on. And it's basically trying to make this whole process less confusing for the employer and the employee. Okay. Number 3, create a culture. We talked a little bit about that. Educate your staff, your supervisors, try to get them to buy in, but just educate everybody on what you're trying to do. And you can do this when you're having new hires. Bring up the return to work program, let them know right away. Safety meetings is a great place to do it. That's how a lot of companies do it. At the time of the injury, review it again. Here's the return to work program, and here's what's going to happen. And then maybe just have it on an annual basis. You're continually educating your employees on what you're trying to accomplish. Tips: as injury first responders, supervisors affect the success of your return to work program. So injuries happen. Usually the supervisor is probably going to be the first point of contact, your first responder. And if they know what to do, they can kind of get the whole process going for you. And again, that's where the whole culture and education comes into play. Train, remind. Train constantly and remind everybody all the time. Communication. This is probably the biggest, in my mind, one of the biggest reasons for having return to work is it does improve in communication. The Bermuda Triangle, if you look, there's usually a breakdown in communication between the employer and the healthcare provider, the employer and the injured worker, or the injured worker and the healthcare provider, or going the other way. By having a return to work program, it puts everybody on the same page. So everybody understands what needs to happen during this whole process. The worker doesn't get frustrated, the employer doesn't get frustrated, and then you have communication within these 3 things that you see there. Number 4, we do have what's called a grab and go kit, which is part of the written program. And I'll just kind of show it here as an envelope. And if you look, again, we can get these online, we can help you create them, but it's a checklist for people to follow so that the employee and the employer are all on the same page. So there's documents in here, the notice of accidents in here. There's a letter if you do have a return to work program to inform the healthcare provider that you do have one in place. You can even throw the job description in there so that the doctor knows what this person's job is like. So when they send a report back to you, they can tell you what they can do and what they can't do. And that's called the provider's report of physical ability. They can charge the workers' comp to fill it out. So little incentive for the doctor to fill it out. That way you get a report back knowing exactly, you know, can your employee lift, how much they can lift, can they sit, can they stand, and so on. So, and then this kit comes back to the employer as quickly as possible after the doctor's visit. So that's one little perk of that, of the program. That's just one piece of it. Let's see, job description should be updated and detailed. We can help you do that. There are websites available to help you do that and help you write a detailed job description. I would try as an employer to have a detailed job description on all my employees. That way, if they do get hurt, you can stick that in the grab and go kit. So when they go to the physician knows their job description. Just makes your life a little bit easier, a little bit of work, but you can get it at the front end. Number 6, when you meet with your supervisors or maybe during a meeting, try to brainstorm alternative tasks that people can do if they are injured. If you have somebody who hurts their back, maybe have some jobs or tasks set aside, written down somewhere. So if someone does come in with that type of injury, you already have some things in mind that they can do to try to keep them employed, or whether, even if it's modified or whatever they got to do. In New Mexico, if you look at the top 5 types of injuries, just to guide you, knees are number 1 injury, lower back, shoulders, ankle, kind of in that order, fingers and hands. So maybe in your business, kind of think of tasks that could be done if somebody had a knee injury, somebody had a low back injury, and so on. Again, it's just pre-planning in case you do need to use some of this stuff. Okay.
All right, thank you, Joey. So I'm going to go back through, and if you have, as Joey said, your blueprint or your plans set up beforehand, once the injury actually occurs, then it's kind of just going down through a checklist. So that was the 6 things to do pre-injury. I'm going to go after the injury. Once the injury actually occurs, if you've got your program set up, you for sure want to communicate. You should have been communicating your return to work policy, all that beforehand, so that way when the injury happens, it's like, oh, okay, I've seen this return to work policy afterwards. You do want someone to sit down with them, to talk to them maybe for 15 minutes, to tell you this is the process. And here's, for example, if we're going to use the grab and go kit, here's the grab and go kit. We want you to take it to the healthcare provider office. Please bring this information back. We're going to try and see if we can accommodate you. So if you can just communicate at the beginning of the claim, that really can save you hundreds of thousands of dollars on misunderstandings at the back end. Employers are sometimes confused, thinking that they can't talk to the employee for some reason after the claim happens. It's quite the opposite. That's really when you want to ramp up communication. You do want to watch the way you communicate. So let's say they do go out on lost time. You don't want to forget about them. We have a tool in our toolkit where there's questions that you can ask. For example, you don't want to call them and say, aren't you better yet? Things like that, right? You want to say, I'd like to communicate with you while you're out on lost time. Do you feel comfortable with me calling you every other week? Something like that. And then call them, see how they're doing. Just don't forget about them. And here is a quote: unhappy, confused workers seek legal counsel, be the worker's ally. And we talked about how expensive the workers' comp claim becomes when legal counsel gets involved, right? So really communicate is a huge key factor. Communicate with the adjuster, the insurance adjuster. They technically work for you. If you see some red flags, let's say it doesn't seem like that worker's getting any better, you're getting those light duty release forms, and it seems like they're still restricted to lift 10 pounds and it's further down the line. Talk to the adjuster, take an active role in the claim. If you do get a light duty work release, make every reasonable attempt to accommodate. If you have good job descriptions, the easiest thing to do is get that light duty work release form that the doctor has given you compared to the job description. If you have, for example, a custodian, said, okay, they can do everything except they can't lift more than 10 pounds for 4 hours a day. So, okay, well, they can still wipe down the mirrors. They can still, do light mopping, do different tasks that you have, but then look at what actually involves lifting. So can you have someone jump in and help them with that part of it? Can you have one of those rolling buckets where they don't have to lift something? What can you modify so that they can still keep doing part of their regular job? If that's not possible, then look at light duties. Is there something they can do outside of their area? So some people think, well, how does that help? They're still contributing to the company, even if they're working outside their job. So we've seen different employers, let's say a custodian again, they can't do any of their custodial duties. Can they do anything to help the business? Can they answer phones, if they have some transferable skills, can they do some filing, some anything that will promote still the success of the business. And you still get all those light or those work or the return to work benefits that we had talked to before. And then your next step, if you can't modify their regular job, you can't do light duty, still consider the more expensive options. Even telework, job rotation. And before you throw in the towel, because you're thinking, oh, I don't have anything at all available for them, still consider part-time. A lot of times they can come in for, let's say, 4 hours a day. The adjuster is happy because it's not, such an expensive payout for indemnity benefits. They're only paying a partial total disability, which is a lot less than full indemnity. So if we were in a live audience, we might ask for accommodation ideas, but you can call us and we can let you know. And here's the incentive to doing the light duty job offers. We do have a template on our website that you can use if you're going to do that. So if you make that a reasonable work offer at the pre-injury wage or and above, and the worker declines, then you are not subject to they're not entitled to the lost time indemnity benefits and the permanent partial disability modifiers, which are those cost points we talked about. So there's the financial incentive to make that light duty job offer that's in the workers' comp statute. You do want to monitor and ramp up with each new restriction. You want to monitor if you do bring them back on light duty, how their progress is going. We do suggest having a temporary time limit where you're checking in with them. You should have a system in place where they have a designee that's you don't want to just forget and then they're on light duty permanently, right? So make sure you're monitoring that, and you want to make sure to investigate each workers' comp claim. And in that way, you can address any ergo faulty equipment, that kind of thing. And you can make those corrections so that you don't have the same injury again. And if you're going to do that, you do want to make sure you tell people ahead of time in your return to work policy. That makes it easier. And people know that it's not a gotcha. You're just going to investigate after every single workers' comp claim. So the homework would be to set up a master grab and go kit, which Joey kind of showed you. I think you found the one. It's like a big blue envelope. You want to, because there's 3 things you have to do after every workers' comp injury. And that is help and communicate your worker. You need to investigate. You need to report. So you can have a kit, basically something to help you prep for doing all 3 of those things beforehand. So everything you need to help and communicate with your worker, such as maybe 5 worker grab and go kits are in there that have your return to work policy in there, what they need to take to the healthcare provider. And if there's any other helpful documents in there that you want to add, everything that you might need to investigate the accident, your witness statement forms, we have some of those on our website as well. And anything you need to report, which are your notice of accident reforms, first report of injury, the online instructions. So assemble those beforehand and you're much more prepared when the workers' comp claim actually happens. So the key takeaways is to work to accommodate all transitional duty, have a plan in place, and don't just abandon your worker to the workers' comp system. Think of them as recovering workers. And in that way, you can control your workers' comp claims costs. Okay, and here's some helpful resources. Those are on our website as well. If you go to our return to work page, there's some things, as Joey said, to help you set up workers' comp, some job descriptions, OSHA, and the job accommodation network that has ideas for how you can accommodate just about every light duty restriction you can think of. So there's some really good resources. And here's our contact information. We have Marietta Valdez. She wasn't able to be on with us, but she's our Southern Return to Work specialist. So you can contact her or I or Joey. And then we have some 6 field offices as well with our phone numbers. And that was all we had. So just trying to really finish in time. Did we have any questions before we hand it back over to Sophia? Right. So anyway, thank you. And if you want to follow up with us, please do so. We can help you with that return to work program. And if you have any general workers' comp questions as well, please feel free to reach out. And thank you and best of luck with your businesses.
See you guys later.
Thank you so much, Jessica and Jose. And if you can please share the presentation with us so we can distribute it to all attendees. Thank you so much and see you soon in another great session. Take care, everyone.